In closing, Attorney-General.
Thank you, Madam Speaker, and I do want to thank all those members who contributed to this very important debate today. The member for Daly, thank you for that contribution, and it was good to hear that you are supportive of this important legislation, this omnibus bill, which does touch on a number of acts across our system. And I will answer those couple of questions that you had that were concerns to yourself. Obviously, that wasn't, maybe those questions weren't asked during the briefing or during the scrutiny part of this bill. And I'd also like to thank the member for Fong Lim as well, who so eloquently summed up all of the important parts of this omnibus bill with those real-life examples of how each section of these changes can actually contribute towards our year of action, certainty and security. And I, in particular, liked your analogy of how we had 8 years of Labor, and these sorts of tidying up bills to modernise what is needed in our justice system, which we do need to be strong, and of course we know hasn't been strong under Labor. And you said that it was a bit like how they are making their front lawn look really good, but out the back it was just all full of weeds. And that's exactly how it felt over the last 4 years in opposition, in listening to the government ministers go through their days. I'm pretty sure sometimes during sittings we would have lots of statements and reports, but not a lot of legislation. So I'm really pleased and proud as the Attorney-General to have brought this to the House and to have had the contributions from the speakers. I'm also proud that it was referred to the Legislative Scrutiny Committee, Madam Speaker, and of course we know that that was scrapped under the former Labor government, and we brought that back in this term of government, and we're really proud of that. And it did go out to far and wide to see who would like to have their views heard, and we did receive one submission from NAJA, the North Australian Aboriginal Agency, and I thank them for that. I thank Anthony Bevan, the CEO over there at the moment, for the work that he did to put forward that, and I will address his concerns as well in part of this wrap-up. Madam Speaker, the bill does make a number of amendments to various legislation and deals with a variety of relatively discrete amendments to various pieces of legislation that fall under my portfolio as Attorney-General. And I won't read through all of them because I did do that in my introduction speech. But I will talk about a couple of the key features of the bill, which hopefully will also answer a couple of the questions from the opposition. So with the Healthcare Decision-Making Act 2023, the amendments under this Act will ensure timely and appropriate care of people with impaired decision-making capacity. To do that, the Act will be amended to follow for the senior practitioner to delegate their functions and powers to a public sector employee who has the necessary qualifications and experience to carry out those functions. This is important because the senior practitioner is not a statutory appointment of a single person who cannot attend to all requests for restrictive practices. We think this is a common sense and much needed change to this legislation. Madam Speaker, the Justice of the Peace Act and Oaths, Affidavits and Declarations Act, my colleague, the member for Fong Lim, touched on the fact that they do such an important role in the community, and sometimes it feels like there's not enough of them, and I can absolutely vouch for that because often there are people in my community who are looking for a Justice of the Peace in particular, and there is a list of people that you can go and find, but if they are unavailable for some reason, it's very difficult. So what this does is ensures that we have those measures in place with those national police checks enshrined in legislation, because we want to make sure that only people who are fit and proper are appointed to these important roles. Madam Speaker, the Misuse of Drugs Act. This bill will amend the Act to make the drug fentanyl and its derivatives a Schedule 1 dangerous drug, which previously listed as a less serious Schedule 2 dangerous drug. This amendment is so important because fentanyl is a very potent and dangerous drug which has a very high risk of overdose. The illegal sale of fentanyl has been increasing internationally, and Northern Territory Police have been encountering more illicit substances where fentanyl is present. So by making fentanyl and its derivatives a Schedule 1 dangerous drug, the sale and supply of this drug can now attract 25 years of a maximum prison sentence, which will deter the spread of this deadly drug in our community. Madam Speaker, the Northern Territory Civil and Administrative Tribunal Act 2014 where currently NTCAT, as we know it as, may make cost recovery orders for costs incurred by a successful party for costs such as filing or service fees. However, there is a current level of uncertainty as to whether the NTCAT must consider this aspect against other considerations. The amendment that I make today will make it absolutely clear that a successful party is entitled to recover the costs associated with filing and serving documents, which are required under the Act. The NARJA submission that I mentioned at the beginning of my address, Madam Speaker, they express their concern that the amendment will point decision makers towards making costs orders. They believe this moves away from the legislated objective of NTCAT, which includes to be accessible to the public and to keep costs to parties to a minimum. However, this change doesn't change that case. It is important to note that NTCAT has always had the ability to make costs orders in favour of a successful party for those costs, like the filing fees or the service fees. What this amendment does is clarify that the NTCAT now may, instead of must, order that a successful party can recover out-of-pocket expenses, because we believe people should not be worse off for using the tribunal successfully to enforce their legal right. The amendment, therefore, doesn't undermine the position of the NTCAT to be accessible to the public or keep costs to a minimum. Madam Speaker, also under the Northern Territory Civil and Administrative Tribunal Regulations 2014, the amendment to these regulations will provide there is no fee associated with an application under the Healthcare Decision-Making Act 2023. This will ensure consistency with the rest of the regulations, which state that there is no fee associated with an application under the Guardianship of Adults Act 2016 or the Advanced Personal Planning Act of 2013. This amendment will ensure consistency for vulnerable people. Madam Speaker, the Residential Tenancies Act of 1999, amendments to include sections 18A and 18B as an exemption for tenancies under the Housing Act of 1982. This particular amendment is in recognition that tenancies made under the Housing Act operate in a different environment to tenancies in the private rental market. Sections 18A and 18B of the Residential Tenancies Act are designed to protect tenants' personal information from misuse, interference or loss by a landlord or a real estate agent. However, they are not practical or necessary in the context of a government-regulated social housing system. Unlike the private rental market, tenancy applications are stored for extended periods on a social housing wait list, which is administered by the agency responsible for social housing. So to answer the question to the member for Daly about what this all means and being really careful to protect our vulnerable Territorians, I guess the point here is that the reason they have to be their personal information by a government agency it's because they're on a social housing or public housing wait list. And we all know in the Northern Territory that our wait lists for social and public housing are absolutely out of control. I think I heard somewhere the other day that someone had been waiting for 10 years to get into a property. And we know that the Minister for Housing is having to do a huge amount of reform in this space to try and get those waitlist times down, not only for those people wanting to get into those properties, but to ensure that those who are already in those properties are actually following the rules and respecting the property that the government is providing to them. Because there are some people out there, Madam Speaker, that just don't do that. They don't allow for their neighbours to live peacefully. They cause a whole heap of problems, and now those reforms will be underway to ensure that those people aren't afforded the expectation of having a house provided by a government. So those wait lists, the whole opportunity is for them to be reduced in some capacity by doing these reforms. So this particular act, it's there and it's needed because the wait lists are so huge. And so it's just a really sensible approach. If we can't keep those names and information as an agency, then they go off into the nether, which is not a good outcome either. We need to be able to know who these people are that are on this wait list. And so it's a very practical approach. It's not anything tricky or fancy, trying to hide anything or trying to make changes to a group of people who the Labor opposition said are very vulnerable. It's about making sure that we still have contact with these people and, of course, try and reduce that wait list, which Labor let get out of control under their watch. Madam Speaker, the Sentencing Act 1995. The bill will insert a provision within Section 48 to explicitly allow for a home detention condition to be ordered for a portion of an intensive community correction order. The amendment will make it clear that the intensive community correction order can contain a home detention condition that applies for part of the duration of the order. While home detention conditions were intended to be an option for courts to impose as a part of an intensive community corrections order, the current provision has been interpreted as an all or nothing approach, and this amendment fixes that issue. Additionally, the bill corrects limitations on the setting of minimum non-parole periods unintentionally established by the Sentencing and Other Legislation Amendment Act 2022. The amendment ensures that a 50% non-parole period applies to all offences where a sentence of 12 months actual imprisonment or more is imposed where no other prescribed non-parole period is applied. The 2022 amendment limited the application of 50% non-parole periods to offences against the Misuse of Drugs Act 1990, offences against the Domestic and Family Violence Act 2007, and to the Sentencing Act of an offender where mandatory sentencing applied, and this amendment expands the application. Madam Speaker, the Land Title Act 2000, this one modernises and accommodates the transition to e-conveyancing practices in the Northern Territory, obviously transitioning the NT to the national framework of electronic conveyancing. And as my colleague, the member for Fong Lim, pointed out, potentially having to go from the paper-based, really clunky, really time-consuming way of doing business when you're trying to buy or sell a home will be made easier with the transitioning into e-conveyancing. And of course, this particularly applies to potentially a younger demographic, and they're the kind of people we want to be buying here in the Territory. We want our first home buyers to be getting into the market. Of course, we have had huge success with our home builder scheme, and we've been able to extend that for another 12 months. And only just on the weekend at my community breakfast, I was talking to a number of people who were so excited about these builds being able to be extended, which means that they're going to be able to now go to their bank, get their loan, use that either $30,000 or $50,000 grant towards building their new home. And we know what it's like when you build a new home, Madam Speaker. You generally stay in it for a very long time, and hopefully you raise a family and those kids grow up to stay here as well. So this is a really good move under the Land Title Act. The commencement of electronic conveyancing will begin in August 2025 and will remove the need to issue those paper certificates during conveyancing transactions. As electronic conveyancing beds down fully, the need for paper certificates will cease over time. However, in the interim, there may be occasions when issuing a paper certificate may be appropriate, such as to the owner of an unencumbered property. The amendment will give the Registrar General a discretion as to when to issue paper certificates. Madam Speaker, the Legal Professional Act 2006, this amendment will allow the NT Law Society to adopt, with approval from the Attorney General, the model Australian solicitor conduct rules in line with other Australian jurisdictions, creating uniformity. Adoption of the ASCR is beneficial to the Northern Territory because it provides consistency for solicitors practicing in the NT. And I know that the Law Society has been calling for this for a long time. Madam Speaker, I would like to thank the Attorney General's Department for all their hard work in working on this omnibus bill, which does cover a number of acts. They've done a lot of work to get to this point, and I'm really looking forward to finishing the passage of this bill, and hopefully we can all agree in the chamber in a bipartisan way to pass this bill and get these efficiencies across some of these government agencies. Obviously, the purpose to enhance efficiencies across a wide range of legislation and across the legal landscape. Madam Speaker, I seek leave to move the third reading. Have I got that right?
The question is the bill be now... Oh, is leave granted? Sorry.
Madam Speaker, I move that the bill now be read a third time.
The question is that the bill be now read a third time. Those of that opinion say aye, to the contrary no. I think that the ayes have it. The Clerk.
A bill for an act to amend the legislation administered by the Attorney General.